Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host. This is our weekly YouTube live stream being broadcast live Thursday, June 14th, 2018 at 9 p.m. Eastern Time. This live stream will also be posted as an episode of the Counting to Five audio podcast. In these weekly live streams, we try to keep up to date with the latest Supreme Court news. And if you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to keep an eye on it and answer questions as they come up. Here's what I plan to cover today. First, new opinions. The court issued a number of new opinions this week. On Monday this week, that's June 11th, the court issued 3 opinions in argued cases, and this included one of the more anticipated cases of the term, Husted v. A. Philip Randolph Institute, and that's a case about the legality of Ohio's system for removing names from the voting rolls. So we'll be talking about those 3 opinions. After issuing those 3 opinions, it was kind of a meager 3 opinions. Court watchers were hoping for a bigger number of opinions than that. But after issuing those 3 opinions, the court announced that it would have an additional opinion day on Thursday. This was not unexpected. It's pretty common at this time of year, especially with so many outstanding opinions left, for the court to add additional opinion days. So today, that's Thursday, June 14th, the court returned and issued 2 more opinions in argued cases, bringing us up to 5 for the week. Now, on Monday, in addition to those 3 opinions in argued cases, the court also disposed of one of its argued cases without an opinion. So let's begin just by talking briefly about that. Now, the case was Washington v. United States, and this is a long-running dispute between the state of Washington and various Pacific Northwest Indian tribes, along with the federal government, which was siding with the Indian tribes in this case. Now, when I say this is a long-running case, I mean it's been litigated in the court for decades, and that's important for a reason I'll come back to in a moment. Now, the basic issue in this case is it deals with a series of treaties from 1854 and 1855, and under these treaties, various Pacific Northwest tribes were guaranteed access to fishing grounds, and specifically to salmon runs. And the tribes argued that Washington was in violation of this treaty by reducing the salmon population. Now, numerous state highways cross these salmon streams, and the culverts underneath these highways are not designed to allow salmon to pass through. So this had the result of cutting off salmon from traditional fishing grounds used by the tribes. Now, the lower courts in this case sided with the Indian tribes. The district court issued an injunction ordering Washington to replace the culverts within the treaty territory. And this apparently would have amounted to more than 800 culverts in the treaty territory. Replace them with a modern design that allows the salmon to freely pass through. Now, Washington challenged this order on a number of grounds, including the interpretation of the treaty itself and the appropriateness of the remedy, this particular injunction. And that was kind of the bulk of the argument in the Supreme Court was about whether this injunction was appropriate. But they also alleged that replacing all of these culverts would have an enormous cost. They estimated at more than $2 billion. And they claimed that it would have minimal effect on the salmon population because allegedly most of these streams have other obstructions, either upstream or downstream of these culverts, which also prevent the salmon migration. Now, the tribes disputed both the cost estimate, which they said was overinflated, and also the impact on the salmon. Now, here's where the case kind of fell apart. Justice Kennedy was recused from this case. Why? Over 30 years ago, when he was a judge on the Ninth Circuit Court of Appeals, Justice Kennedy was involved in an earlier stage of this case. I mentioned this case has been going on for decades. Now, this conflict was discovered late in the process. The case had already been granted by the Supreme Court and scheduled for argument, but before oral argument occurred, the conflict was discovered and Justice Kennedy recused himself. Now, it's not that surprising that this got missed. Justice Kennedy has heard between his time on the Supreme Court and his decade plus on the Ninth Circuit Court of Appeals, he's heard thousands of cases. And it's easy to imagine that a single case from more than 30 years ago would have slipped his mind and not been easily spotted. But the result was this left the court with only 8 justices to hear the case. Now, this wasn't a case that had really obvious ideological divides. It wasn't necessarily clear how the justices would vote or what the final breakdown would look like. But on Monday this week, the court issued a simple one-line order that just said, the judgment is affirmed by an equally divided court. Now, what this means is the justices were evenly split 4-4 on the outcome in this court. And under the court's practices, when this happens, the lower court opinion stands, it's affirmed and remains in place, but there's no Supreme Court precedential value to this affirmance. So the fact that this is affirmed by this evenly split 4-4 court, it means for the particular litigants in this particular case, whoever won below retains their victory, but it isn't something, it can't be relied on as a Supreme Court precedent going forward. Now, as is the court's normal practice, there are no opinions explaining why any of the justices voted in a particular way in this case, and there isn't even any indication of which justices voted which way. So it's just a matter of speculation, who are the 4 on one side and the 4 on the other side. The ultimate result in this case, the tribes win. So Washington will have to go ahead with starting to replace these highway culverts. So before we get on to the cases, just one more quick piece of news from the week. The justices' 2017 financial disclosures were just released. Among other things, these show the justices' stock holdings. Now, there are only 3 justices on the court, and that's Chief Justice Roberts, Justice Breyer, and Justice Alito, 3 justices who own individual stocks, as opposed to mutual funds or other types of retirement accounts. Now, this holding of individual stocks is somewhat controversial because it occasionally causes one of those justices to have to recuse themselves from a case that involves a company that they own stock in. And it has in recent years involved some missed recusals, cases where a justice did not immediately recuse, for example, because the party in the case was a subsidiary of a company that they own stock in, and they didn't immediately catch the conflict. Now, as we just saw in that Washington v. United States case, the Salmon case, recusals at the Supreme Court can be a big deal. Now, at the lower courts, a recusal is not such a big issue, because in most cases, another judge can just be substituted in for a judge that has a conflict of this type. So it's not such a big deal. But at the Supreme Court, where there's no justices that can step in the case of a conflict, it's a much bigger impact when a justice has to sit out a case. And so these individual stock holdings have been criticized as just causing unnecessary recusals, because a justice could easily move their money into either a blind trust or a mutual fund or some other vehicle that doesn't cause these kind of conflicts with individual companies. Now, from 2016 to 2017, the total number of individual stocks held by these 3 justices went down from 49 different stocks to 44. Each of the 3 justices sold off at least some of their stocks this year, and that's been part of a gradual year-by-year decline as the justices have slowly divested themselves of these stocks. But 44 is still a significant number, and of the 3, Justice Alito holds the most different stocks in his portfolio. These financial disclosures also show that all of the justices earned at least some extra income from things outside of the Supreme Court. Many of them, this was from teaching. Many of the justices teach over the summer, often in foreign countries. It's kind of part of some international travel combined with teaching duties. But with that out of the way, let's move on to some additional business. So cert grants, new cases. There were no new grants this week, and this is the 2nd week in a row. That's somewhat unusual this time of the year for the court to go 2 weeks in a row without granting any new cases for next year. That leaves the total for next term at 18 cases so far. Now, we're keeping an eye on this because we want to see how full the court's fall calendar will be. Just due to the timing, the schedule of briefing a case, basically the fall calendar, that's the October, November, and December oral argument sessions, the cases for those months basically have to be granted before the court leaves for its summer recess. Now, based on recent years' grants, it looks like the court is unlikely to hit that number, have a full fall term, which again would be typical for the last few years. But you never know, because typically the final grant list in June, the cases that get granted in the last week of June, it's one of the largest single grants of cases of the entire term, typically second only to the first set of grants after the summer when the court returns in the last week of September. So we'll likely get a decent number of cases granted in the court's final week, and between the next 2 weeks, the court, it's conceivable the court could add enough cases to fill up that fall calendar, but we won't really know until it happens and we see what cases actually come down. So with that out of the way, let's move on to the new opinions for the week. I mentioned there were 5. Now, before this week, the court had 25 outstanding cases, 25 argued cases that were still waiting on opinions in, with only 3 weeks left of the term. But between Monday and Thursday this week, the court issued opinions in 5 cases. It also got rid of the evenly divided Washington case that we already discussed. So that leaves 19 cases to go, but only 2 more weeks left. So this is a very heavily backloaded term, and there's still quite a few high-profile cases pending among those 19 that are left to go. There's maybe 6 or 7, depending on how you count. Maybe more, actually, depending on what you count as significant. So there's still a lot left to come, and it's going to be a crazy a couple of weeks coming up after this week for the court to get rid of the rest of its cases. Now, it's not a there's no rule or legal requirement that the court has to issue all of its opinions from this term by the end of June. It's a self-imposed deadline from the court, and the justices plan their summer plans accordingly, expecting to have all these opinions out before the end of June. And it's been a long time since the justices have missed that deadline, more than 20 years. So it's the general consensus is that it would be very unlikely for the court to miss that deadline and slip into July. But again, there's things can happen, and we'll just have to wait and see. But I think the safer bet is that the court will manage to get all these opinions out in the next 2 weeks. But again, we never know. Now, in terms of the total number of opinions for the term, the court heard oral argument in a total of 63 cases, and this is low by historical terms. It's part of a decades-long downward trend on the court of hearing fewer and fewer cases. But also, among those 63 cases, so far 3 of those cases have been disposed of without real opinion on the merits. Now, one was United States v. Microsoft, which was dismissed as moot due to a new statute passed by Congress. That was a case about the Stored Communications Act. It was whether the government could seize emails stored overseas in a criminal investigation. One case was called City of Hays, Kansas v. Vote. That was a strange little case about the Fifth Amendment right to against self-incrimination, and the court dismissed that as improvidently granted, meaning basically they learned that the case had complications that the court just didn't want to deal with, so they just got rid of it. And then the third was the Washington v. United States, the salmon case that we already talked about. So that leaves them with only 60 real opinions in argued cases at most. That's assuming all of the rest of the cases get decided with a full opinion. And that is basically, that's an unprecedented low. That has not happened any time in modern history. I've seen at least going back to the 1940s, it hasn't happened. And I don't believe, I think you can go back much further than that. And there hasn't been a term with this few argued cases. Now, it's not impossible also that one or more of those remaining 19 cases could also be disposed of without an opinion for some reason. So again, we'll wait and see, but this is a very, very low year in terms of the total number of opinions. So let's move on and talk about those new opinions for the week. So there were, again, 5. 3 of them came on Monday. So let's just talk about the first of them. It's a case called China Agritech v. Resch. Now, this was a unanimous decision. It had a majority opinion by Justice Ginsburg for 8 of the justices, and Justice Sotomayor wrote a separate concurrence disagreeing with the scope of the court's rule. So she decided the same way in this particular case, but disagreed with some of the majority opinion. Now, this is a case about something known as equitable tolling. So just for some brief background to understand what this case is about, statutes of limitations are time limits that are imposed on bringing a particular legal action, and there are different time limits for different types of actions. In this case, there was a 2-year statute of limitations. This was for a securities fraud claim. But there's a concept known as tolling, and that's when the statute of limitations is basically paused. It's suspended for a period of time, and then once the tolling ends, that it continues to run. That this 2-year time period could continue to run once the tolling lifted. Now, sometimes there's specific rules or statutes that require a statute of limitation to be tolled for periods of time. But there's also a concept known as equitable tolling, which are some court-made tolling rules that are designed to just prevent unfairness to certain parties, and they allow in certain circumstances for statute of limitations to just be kind of put on pause for a period of time. And the specific type of equitable tolling in this case is known as American pipe tolling, which is named for a case called American Pipe and Construction Co. v. Utah, a 1974 Supreme Court case. And the basic idea of the rule that comes out of American Pipe is when a class action is filed, then the claims for all of the people who would have been members of the class, as the class is defined in the class action, their claims are tolled for the period until the class action is certified. Now, just to explain very briefly, a class action is when someone brings legal claims not just on behalf of themselves, but on behalf of also other similarly situated people. So people that had similar legal and factual claims against the defendants in the case. And the idea is that all of these claims can be decided together in one legal action, and this has great benefits for efficiency, and also allows actions to be brought for claims that wouldn't be worth enough money to sue on all by themselves. But when you aggregate them together with many other very similar claims, it's then worthwhile to sue on. Now, one of the important steps in any class action is what's known as certification, and that's when the court determines that that this case is suitable to go forward as a class action, and it involves determining that the factual and legal issues in the case are similar enough across the particular class. And there's several other considerations. Also, they want to determine that the individual plaintiffs, the named plaintiffs in the case that brought the case, are sufficiently representative of the claims of the entire class. But in any case, a court has to certify that a class action can go forward. Now, this doesn't always happen. Sometimes a court will determine that there's just, for example, too much variation in the individual claims between the various members of the defined class, and so it's not appropriate for this to be tried together as a class action. So what American Pipe Tolling does is it says that if a class action is not certified, then any people who would have been members of that class, they're still free to bring their own individual claims. So when a class action is not certified, the named plaintiffs in the class action, the people who actually brought the action to court, those people, their individual claims can still go forward. They just can't bring it on behalf of a whole class. And other people who would have been members of the class could bring their own actions. Now, the statute of limitations, however, might have run out during the course, while this class action was pending before the certification issue was decided. They might have lost their opportunity to file it. So what American Pipe Tolling says is that when a class action is filed, for that period from when it's filed until a certification is denied, the statute of limitations is tolled, so that once the certification is denied, those other people who would have come into the class action can now have an opportunity to bring their own individual claims, and they haven't been barred by a statute of limitations. And the idea here is that one of the ideas is that it prevents the need for people to file duplicative filings. It means that if a class action is filed and you're someone who's would be a member of that class action, if it's certified, you don't have to rush in and file your own action in court, or make a motion to try and intervene in the class action to get yourself into the case just in case it's not certified as a class action. You can just wait it out, see if the class action is not certified, and then if you need to, file your own action. And this prevents all kinds of the need for duplicative filings for people just to protect their rights and prevent a statute of limitations to run. Now, American Pipe Tolling is a controversial decision among certain critics of class actions, because some people believe this kind of court-made exception is not appropriate in this area, but it is the binding, or the governing law of these class actions. So here's the specific issue in this particular case. This was the third consecutive class action against China Agritech for securities fraud. Now, the first class action was brought. That class action was not certified due to a failure to show that there was sufficiently similar facts across the entire class. The class was not certified. Now, new plaintiffs brought a second class action with basically the same securities fraud claims. Within this, then this was still within the statute of limitations period. They brought the second class action. I'm sorry, my live stream feed cut out for a second. I hope you're still with me. But I was just saying that a second class action was filed by different plaintiffs, but with basically the same securities fraud claims. That class action was also not certified, and for that time it was for the reason that the named plaintiffs in the case were determined not to be good representatives of the whole class. So here's where this case comes down. This is a third class action by new plaintiffs with the same securities fraud claims against China Agritech, but this one was filed after the expiration of the 2-year statute of limitations. Now, if American pipe tolling applies to those first 2 class actions that were filed, and the statute of limitations is tolled for those, then this third class action is still within the tolled statute of limitations and can go forward. But the question is, the argument made in this case was that American pipe tolling should only apply to new individual actions, not to a new class action. And so does American pipe tolling apply? Now, Justice Ginsburg, for this majority, again, this is a unanimous opinion, and she wrote for an 8-justice majority, says, no, American pipe does not apply. Tolling is for individual claims only. Now, Ginsburg's majority opinion, it basically says, American pipe tolling, the idea there is it's based on efficiency. It prevents unnecessary filing of motions to intervene or duplicative actions and preserves rights. But those efficiency benefits don't really exist for successive class actions. She says, while courts don't want, when a class action is filed, they don't want to be bombarded with numerous individual actions also that are just going to clutter up the courts. If there are additional people who want to file class actions, it's better for all of those class actions to be filed as early as possible, not wait for the certification decision, but have as many class actions as are going to be filed early to allow the court to possibly consolidate those class actions, to allow them to potentially select good class representatives from among multiple class actions. Just for efficiency, it's better to have all those out early. So she says the efficiency benefits don't really exist. She points to Federal Rule of Civil Procedure 23. Now, that's a specific rule that has the procedures for class actions, for bringing a class action litigation. And she notes that instructs that the class certification decision should be decided at an early practicable time. And she says that this is a reason why you want anything like any class actions, any sets of potential lead plaintiffs in class actions that might be relevant to the certification decision to be in the courts as early as possible. But she also points to another statute, and this is specifically relevant to this case because it's a securities fraud case, and it's a statute called the Private Securities Litigation Reform Act. It's just referred to as the PSLRA, which is a 1995 law that imposed various more stringent rules on securities fraud lawsuits. And specifically in reference to securities fraud class actions, it requires notice to potential class members early on to allow them to apply for lead plaintiff status in the case, to be one of the representative plaintiffs in the case. Now, Justice Ginsburg points out that equitable tolling, the idea behind American pipe tolling, this idea of judge-made tolling, one of the things that is always required is a showing of diligence. It's a showing that the plaintiff acted diligently. And in American pipe, the court said that was done because it was perfectly reasonable for those plaintiffs to wait out the class certification process in the first action and not move then. So hadn't failed to be diligent by not filing their action while another action was pending. But Justice Ginsburg says here, when a plaintiff could have tried to intervene or file their own action to become a class representative in the first filed class action, but didn't, then they hadn't showed the necessary diligence in order to be able to allow to represent a class in the second new action, later action. And Ginsburg's opinion also points to potential bad practical effects of allowing tolling in the situation. She says that it would allow repeated extensions of a statute of limitations through successive class actions. Now, if you have a large class of individuals, every time a class certification is denied, the lawyers could potentially just find a new plaintiff who wasn't named in the earlier action and file a new class action. And if that is denied, find a new plaintiff and just repeat just repeatedly. Now, for individual tolling, it's basically one extension, because once a class action is not certified, an individual can file their own individual action, and then that action will just go forward on an individual basis. But this is different with a class because it could just keep going and going and going. She also argues that this rule that they're applying here, it doesn't deny anyone their rights under Rule 23. That's the class action rule, because in the first place, there is no right to bring claims after the expiration of the statute of limitations. It's just this judicially crafted tolling rule. It's an exception, and the court need not extend that to these class claims, this exception that they crafted for the class action situation. And she also addresses some practical concerns and says that it's unlikely that this rule that the court is laying down here will result in some huge number of protective class filings. That hasn't been the experience of the circuits that have already adopted this rule earlier, because there was a circuit split about whether this was allowed or not. And those that are filed are manageable, can be managed by the courts through consolidation or other means. So that's the majority opinion. And then moving on, Justice Sotomayor, I mentioned, she concurred, but did not join the majority opinion. Now, she agrees with the majority only for actions under the PSLRA. That's the Private Securities Litigation Reform Act. And she points specifically to the early notice action under the PSLRA. Under that statute, when a class action is filed, a securities class action, notice has to be published within 20 days of that filing. So that's a published notice that would let people know of the existence of the class action. And then there's a 60-day deadline in order for people to make a motion to have lead plaintiff status. So other members of the class could come into court and say that they wanted to be potentially lead plaintiffs in the action. So she says this shows an expectation that anyone who wants to be a lead plaintiff will come forward in that first action. And here, plaintiffs in this later action, they had not sought lead status in the first two actions, so they cannot show the diligence that's required. But then where Justice Sotomayor differs is looking at the Rule 23 class action. That's just a regular class action and not in the securities context. And she notes that there is no notice prior to certification normally. And also there's an assumption generally that the first person to file, the named plaintiffs in the first filed action, will be the lead plaintiff unless there's some particular problem with them. So other members of the class may not even know that a class action exists, and even if they knew, they'd have no reason to file their own to try and intervene to become a lead plaintiff, because it would most likely be futile, and they'd have no reasonable likelihood that they would be chosen over the actual named plaintiffs in the filing. So she says here it just doesn't show that they were in any way not diligent in not trying to become a lead plaintiff right from the start. She does note that this concern about limitless tolling, that this could just go on and on and on and on, could be a real problem, but says that the courts have ways of working around that. For example, she suggests that comity, that's COMITY, that's the idea of one court kind of giving respect to the decisions of another court. That might be a means to address this repeat litigation by saying that these later filed class actions should respect decisions of the earlier courts, to not just give the plaintiff's attorneys just infinite bites at the apple. And also suggests that maybe the court should make a decision between when a case wasn't certified for class-wide reasons, because they thought that the claims just were not suitable for class action treatment, versus when a class isn't certified because the particular class representatives weren't appropriate. Saying that when the representatives weren't appropriate, you should allow new representatives to come in and file a new action. And that's the court could kind of make an equitable distinction between these two different reasons for denying certification. She also points to a potential negative effect of the majority's rule. She argues that when there's multiple class filings, so this encourages multiple class action filings early on, and this can potentially lead to a race to judgment. That's where the lawyers know that only the first case of class action, when there's multiple class actions on the same claims, only the first case that gets to a settlement, the lawyers are actually going to end up getting paid. The rest of the cases are going to be basically precluded because there's already been a settlement in one case, and so it causes this race for lawyers to potentially underbid each other for a settlement in order to get paid in the case. So that's that first case. Let's move on to the next case from Monday. This is a case called Sveen v. Mellon. And this is a pretty unusual case because it deals with the contracts clause of the U.S. Constitution, which is not often litigated. And it's a dispute over the beneficiary of a life insurance policy. Now, here's the simple facts. In 1997, a Minnesota couple, the names are Mark Sveen and Kay Mellon, they got married. In 1998, the next year, Sveen added Mellon as his primary beneficiary on his life insurance policy. So that's 1998. Now, in 2007, Sveen and Mellon get divorced, and in 2011, Sveen dies. Now, the issue here is competing claims by Mellon, that's the ex-spouse, and Sveen's children from a prior marriage over who should be the beneficiary. Now, why is this an issue? Minnesota has a law that was enacted in 2002 that's what's referred to as a revocation on divorce law. And what it basically says is when a married couple gets divorced, the ex-spouse is removed by act of law as the life insurance beneficiary. The idea here is that many people never update their insurance beneficiary information, and there's an assumption that in general, most people who get divorced don't intend to keep their ex-spouse as a beneficiary. So this creates this default rule that's intended to track people's common intentions. So what it'll do is a couple gets divorced, the spouse is removed as the primary beneficiary. If the person dies, then it would go to the secondary beneficiary on the policy, or it would just default to go to the person's estate if there is no other beneficiary is named. However, this is just a default rule. It can be overridden. The policyholder after the divorce could re-add the ex-spouse as a beneficiary if they wanted to. There could be specific contractual language in the policy that said that even on the event of divorce, the person was going to remain in, or a court decree in the divorce proceedings when there's a divorce settlement could specify who's going to be the beneficiary of the life insurance policy. So this is just a default rule. Now, this is a pretty common approach. There are apparently about 26 states that have very similar laws, and some other states frequently take a similar approach through divorce court proceedings. Now, this is also in a different context for wills as opposed to insurance policies, but for wills, it's pretty much a universal or near universal rule that upon divorce, or after a divorce, if a will has not been updated, the court will not treat the ex-spouse as a beneficiary under the will. And this Minnesota statute was based on what's called the Uniform Probate Code, which was basically a effort at a model statute to govern these kind of death-related provisions. So Minnesota is not an outlier. It's a fairly standard approach. Now, here's the problem. This law was enacted in 2002. That was after the insurance policy was already in place. That dated to 1998, but before the couple had divorced. Now, the contract clause of the United States Constitution, it says, this is just in relevant part, it says, no state shall pass any law impairing the obligation of contracts. So the argument here was that by enacting this law that affects a previously entered into contract, the state of Minnesota is violating the contract clause by impairing this contract. Now, the contracts clause dates. It was prompted by concerns about debt relief laws that were passed by states during the post-Revolutionary War period, the intention was to promote investment by making contracts more secure. But at least according to kind of one recounting of the history, starting in the late 19th century and then kind of coming to its climax during the Great Depression, the Supreme Court started making various exceptions to the contract clause, and eventually kind of watered down the contract clause so that it ceased to have as much bite as it used to have. Now, the modern test for the contract clause doesn't ask whether there's any impairment of the obligation of contracts, but asks whether there's a substantial impairment of contract rights. And then if there is, asks whether the law serves a significant and legitimate public purpose and whether the law is a reasonable means of achieving that purpose. And if it is, then it's allowed to survive this test. So this case was an 8-1 decision, with Justice Kagan writing the majority decision and Justice Gorsuch as the lone dissenter. Kagan decides this Minnesota law is constitutional, and she relies on, under this modern test for the violation of the contract clause, she says that this survives just looking solely at the first prong, the substantial impairment. She says there is no substantial impairment here. She says this law is intended to reflect the policyholder's intent. There's a long history of statutes that are trying to protect, for example, a testator in a will situation, protect their expectations after certain life changes like a marriage, a birth of a child, or divorce. And the failure of someone to change a policy is more likely due to their inattention rather than a deliberate choice to leave their ex-spouse on the policy. So this isn't really impairing the likely policyholder's intent. And she also says it's unlikely to disturb people's expectations because there was always a possibility that divorce courts could overrule these beneficiary designations in the first place. And also that it's just a default rule. The policyholder can always override this by submitting a new beneficiary designation. So this is basically just a paperwork requirement, and there are precedents that have allowed new paperwork requirements as not violating the contract clause. Now, Justice Gorsuch dissents, and he strongly rejects the majority's argument that changing what he refers to as the most important term of a policy, he rejects the idea that could not be a substantial impairment of the law. And he refers to he goes on, he talks about how the contract clause basically constitutionalizes the basic principle that statutes are generally deemed to be non-retroactive. They generally, most statutory law applies going forward only, and the contract law kind of constitutionalizes that, makes that an absolute rule for purposes of impairing contracts. And it's written in absolute terms. It says, no state shall pass any law impairing the obligation of contracts. He also says that during the drafting and ratification of the Constitution, the desirability of this absolute contract clause was actually debated during that time, and it was enacted in this kind of very absolute terms anyways. And then he goes on to talk about the modern test, this allowing a substantial impairment if it's in pursuit of a reasonable effort in pursuit of a significant and legitimate public purpose. And he says that really can't be squared with the original meaning of the contract clause, and that basically this modern test risks reducing this protection to a court's judgment about the reasonableness of legislation. And he says that the criticisms of this modern doctrine ought to be squarely faced by the court. The court hasn't really done that. But he goes on and he says, under this modern doctrine, he says this is certainly substantial impairment. And here's what he says. This is a quote: "No one pays life insurance premiums for the joy of it, or even for the pleasure of knowing that the insurance company will eventually have to cough up money to someone." He's emphasizing the fact that who the beneficiary is of supreme importance to someone having an insurance policy. And he also points to some factual allegations in this case that kind of might point to a specific unfairness. There's an allegation here from Mellon, that's the ex-spouse who was arguing that she should receive the benefits here, that she and Sveen both kept each other as beneficiaries on each other's life insurance policies because they remained friends after divorce and had paid the premiums on the life insurance from a joint checking account. Now, we really can't know on the record what Sveen's true intent was here, but it's clear that the retroactive removal of Sveen from the policy undid a central term of the contract that Sveen had left in place for years after the divorce happened. So that's Gorsuch's argument here that this has to be a substantial impairment. He also points to the fact that the federal government and almost half of U.S. states don't revoke beneficiaries upon divorce don't have a rule like this. And he says there's many plausible reasons why a policyholder might want to keep the beneficiary. For example, a sense of obligation toward the ex-spouse or the care of minor children and other things like that. And he also says that the majority's admission that this presumption is sometimes wrong, the fact that some people do want to keep their ex-spouse on the policy, the fact that they admit that should end this question, basically. Sometimes this undoes a central term of the contract. And he says, this is another quote, "I do not see how a statute doesn't substantially impair contracts just because it reflects many people's preferences." And he says basically the constitutional rights are supposed to protect majority rights against majority desires. But he goes on to say, okay, so this is a substantial impairment. Was it reasonable? So under the modern test, does it meet this reasonableness requirement? And he says, basically, he argues this was not necessary to serve the state's goal. He says there are many alternatives. For example, the state could have required divorce courts to address life insurance beneficiaries in their divorce decrees, or require divorce attorneys to advise their clients on life insurance when they're discussing the impacts of divorce, things like that. And Minnesota didn't consider any of these alternatives. So, that's the major arguments that Gorsuch makes in this case. Now, one interesting thing to note is Gorsuch is alone here. Maybe slightly surprising that he isn't joined by Justice Thomas. They are very frequently allied. Gorsuch and Thomas have been together on a number of separate opinions over Gorsuch's time on the court so far. Thomas is a frequent solo dissenter and has a tendency to like to revisit longstanding precedents and gives great weight to the Constitution's original meaning. So many might have thought that he would be a likely ally for Gorsuch on this, but he joined the majority and did not join Gorsuch's dissent in this case. So let's move on to the next case. This is Husted v. A. Philip Randolph Institute. Now, this is probably the highest profile case of this week. This is an election law case out of Ohio. There was a challenge under federal statutory law, a challenge to Ohio's process for removing names from the voting rolls. Now, this case broke along 5 to 4 lines along the kind of stereotypical conservative liberal divide. The majority opinion was by Justice Alito. The 4-justice dissent was by Justice Breyer. And there was also a separate concurrence just by Justice Thomas and a separate dissent by Justice Sotomayor. So start with Justice Alito's majority. Now, he frames this case as a case about Ohio's attempt to deal with the problem of inaccurate voter registrations. He cites some statistics saying that there's an estimate of 24 million invalid or inaccurate voter registrations. This is about 1 in 8 voter registrations, including millions of voters who are registered in more than one state. And in Ohio, as in pretty much everywhere, voters who move out of the district that they're registered in are ineligible to vote in that district. And according to census data, roughly 10% of Americans move every year. So a significant number of people are moving around in ways, presumably, that would make them ineligible in the place where they're currently registered. Now, the key law in this case is the National Voter Registration Act from 1993. And in this framing, there were 2 main goals of this act. One was to increase voter registration, but the other goal was to remove ineligible voters from the voting rolls. And there's a requirement of this law that states have a program that makes reasonable efforts to remove the names of voters who are ineligible due to death or change of residency. Now, there's specific, also, this is very important, there are specific requirements in the statute for delisting someone, removing someone from the rolls due to a change in residence. If a state is going to remove someone from the rolls due to a change in residence, they need either a confirmation in writing of the change of residence, or they need to send a notice with a pre-addressed postage prepaid card to the registered voter, informing that the person that they either have to return that card or vote basically within the next 4 years in order to remain listed. And if they don't do that, if they don't either return the card or vote within 4 years, then they will be removed from the voting rolls. So that's a specific requirement of the statute that states have to go through those steps if they want to remove someone for change of residency. Now, the statute does not say when this kind of notice has to be or can be sent. Now, some states do it only when there's a postal change of address form filed, but other states send this to basically everyone every year statewide, send it to everyone And if they don't get a response and there's no voting for 4 years, those people would be removed. Now, Ohio does something different. They use another factor, which is the failure to vote for a 2-year period of time. So if someone in Ohio is registered to vote, they don't vote for 2 years. They then after those 2 years, they would receive this card in the mail, and if they failed to return that card and failed to vote for another 4 years, they would be removed. And here's the key provision at issue in this case. There's another provision which is referred to as the failure to vote clause, which says a state program shall not result in the removal of the name of any person by reason of the person's failure to vote. Okay, so can't remove someone by reason of failure to vote, but there's another provision that says part of it that says nothing in this prohibition may be construed to prohibit a state from using the procedures described in, and it talks about the certain sections about that, the card and the 4-year period. So nothing should be construed to prohibit a state from using those procedures to remove an individual from the official list of eligible voters. So those two provisions together, you can't remove someone by reason of the failure to vote, but this shouldn't be construed to prohibit that 2-step process with the card plus the 4-year waiting period. So what does this all mean? And basically, what it comes down to is the majority and the dissent disagree over how to read these two provisions together. Now, one potential possible reading, and this is the reading that Justice Alito adopts, he says that when you read these two together, you're saying you have to interpret that prohibition, you can't exclude someone by reason of the person's failure to vote. You have to interpret that to be consistent with this other procedure that allows you to send this this prepaid card and then remove someone if they don't vote for 4 years after that. And so what that says to Justice Alito is that indicates that this 2-step process, this card plus the 4-year period, is not removing someone by reason of the failure to vote. The fact that there's this other step in there, the possibility of them returning this the pre-addressed card, means that this is not by reason of the failure to vote. It's by reason of this confirmation, the failure to comply with this confirmation process. On the other side, and this is an opinion expressed in Justice Breyer's dissent, it views this provision, the confirmation followed by the 4-year period, as kind of a carve out, an exception from the general principle that you can't do something by reason of a person's failure to vote. And so Ohio's initial decision to send someone a card to have this triggered by their failure to vote for 2 years violates this failure to vote clause under the dissent's view. Now, so Justice Alito also points, here's another our argument from the majority. It looks at the history of this the act at issue here, and notes that prior to this act, failure to vote was actually grounds for removal from the rolls in some states, not as evidence of a change in residency as Ohio uses it. So Ohio uses this 2-year failure to vote period as evidence that someone has changed their residency, and then goes through the mailing of the card and the 4-year waiting period to confirm this change of residency. But prior to this act, prior to the NVRA, some states used failure to vote as grounds for removal itself. So you could just automatically be removed purely on the basis of not voting. So don't vote for a certain period of time, you get removed, not because the state's assuming you moved, but just because if you don't vote, they want to take you off the rolls. And so the argument here is that's what this provision was intended to prevent, and that has been eliminated. States no longer can use just a failure to vote by itself as grounds for removing someone from the voting rolls. So that's kind of his understanding of why this prohibition still makes sense and still has effect. And he addresses some practical arguments. There's an argument that's been made that basically people just don't return these cards. These prepaid cards just end up getting thrown out, and just routinely people throw them away. So the failure to return these cards just doesn't provide good evidence that someone has actually moved. So that effectively means that people are being removed on the basis of not voting because the cards are ineffective. Alito rejects this, saying basically that Congress specifically rejected this argument by explicitly writing this card requirement into federal law, the mailing of a card followed by the 4-year waiting period as the prescribed way of removing someone for change of address. So Congress has rejected the idea in the statute that this failure to return a card is not good evidence of change of address. So that's the basic idea of the majority opinion. And as I mentioned before, the Breyer opinion has just a very different interpretation of the import of the failure to vote clause. But there's another argument that the majority makes, which is that the requirement of the statute, or I'm sorry, this is another argument the dissent makes. It argues that the statute specifically requires states to conduct a general program that makes a reasonable effort to remove the names of ineligible voters from the official list of eligible voters. And he looks at that phrase, that must make a reasonable effort, and says that the courts have a role in determining whether something is a reasonable effort, and then goes on to kind of examine the statistics that the court has been presented with about how often people return these cards and such. And it basically just argues that returning these cards is just not a reasonable proxy for change of residency. It compares it to other processes like postal change of address forms, which are much more clearly connected. And he also another provision that of the federal law that allows someone who fails to return. That when mail is sent to an address that's non-forwarding mail and it's returned as an undeliverable, that can be used as an indication that someone has changed address. And he points to those as kind of more reasonably connected, but says that just a failure to return these prepaid cards is not reasonably connected to residency. So this is not a reasonable effort and should fail under those terms. Now, Justice Alito disagrees with that also and says that Congress has made this judgment that the failure to return a card or vote for 4 years was reasonable because they wrote that directly into the law. So he rejects Breyer's position there. Now, I'll briefly move on to the two other opinions in the case, Justice Thomas's solo concurrence. Now, he joins the majority in full and says he believes that the majority's interpretation of the statute is correct, but he also argues that the position in the dissent's position would raise some serious constitutional concerns. And the reason he gives is he believes, under Justice Thomas's reading, he believes the Constitution gives states the exclusive authority to set the qualifications for elections and determine whether those have been met. And says that by preventing Ohio to use the failure to vote as evidence of change of residency, it would infringe on the state's exclusive authority here. Now, this opinion relies heavily on a couple of Justice Thomas's previous dissents in election law cases. So this represents kind of an idiosyncratic position on the court that hasn't been fully endorsed by the rest of the court. Justice Breyer, in his in the dissenting opinion, specifically replies to Thomas's position, saying that the court's precedents show that the federal power to regulate the time, place, and manner of elections has been construed as broad enough to justify this type of law. And also, he argues that this doesn't actually regulate who can vote. So it's not regulating the eligibility to vote. It's just regulating the manner of registering those people or keeping them registered. So that brings me to the final opinion in this case. This is a dissent by Justice Sotomayor. Now, she also joins Justice Breyer's dissent in full, but she emphasizes the purpose of the NVRA, the National Voter Registration Act, the purpose of increasing voter registration, and points to the history of disenfranchisement of low-income and minority voters, and emphasizes a potential disparate effect on minority populations of this Ohio policy. Now, Justice Alito replies to this in his majority opinion and basically says that this is legally irrelevant. He says the challengers didn't bring a claim under provisions that bar discriminatory programs. They just brought it under this failure to vote clause. But Justice Sotomayor responds to that, saying it's relevant to interpreting the statutory text in line with Congress's purposes. So she sees this as kind of a relevant consideration in determining what's the right interpretation. All right. Those are the three decisions that were issued on Monday. In a second, I'll move on and try and quickly go through the two decisions that came down this morning. Before I do that, I'm going to step back and answer one question. I had a question in the live chat from Sam A. And the question says, what would be the broader implications if the court adopted Justice Gorsuch's dissent in the Contracts Clause case? Now, that's an interesting question, and there is some dispute on that because part of it depends on kind of how broadly you or how you interpret some of the court's earlier decisions before the time period where people say that the court kind of cut back on its contracts clause doctrine. And under some reading of those earlier opinions, the state still had a bit of leeway to do things like adjust the remedies that people could receive under certain contracts without actually impairing the actual rights people had under the contract. So they might have to enforce the contract in a slightly different way, but their rights wouldn't be impaired. And that was deemed to be okay. And in other cases, the state was able to impair people's contractual rights if they paid compensation for that. So if they somehow compensated people whose statutory rights were had been diminished by a law that kind of impaired contracts in some way. So that gave states some more flexibility under those earlier precedents that Gorsuch would favor. Now, it's important also to point out that nothing in Gorsuch's opinion affects the laws like this or any law that affects a contract prospectively, so going forward. So Gorsuch doesn't dispute at all that the Minnesota law at issue he doesn't dispute that could affect any contract that was entered into after that law was enacted. So that law in this particular case was enacted in 2002. Anyone who designated a beneficiary after 2002 could be governed by that law without any implication of the contract's law clause because it wasn't impairing an earlier entered into contract. So that would reduce the impact some because states could always go forward prospectively and change the baseline rules or impose limitations on what people were allowed to do with contract. But beyond that, I don't have a good, I'm not an expert in the contracts area or anything, so I don't have a great sense of exactly how broad it would be. But those are just some considerations there. So hope that at least partially answers that question. So moving on to the Thursday cases, there were two cases this morning. The first was a case called Animal Science Products v. Hebei Wellcome Pharmaceuticals Company. And this was a unanimous opinion by Justice Ginsburg. Now, here's some brief background in this case. In numerous circumstances, a case in an American court might depend on the law of some foreign country. Now, here's the specific facts in this case. Animal Science Products brought an antitrust action against Chinese vitamin manufacturers, alleging that they were engaged in illegal price fixing. Now, these vitamin manufacturers, the Chinese companies, they raised a defense that the price fixing was actually required by Chinese law. Now, this could be a valid defense to the antitrust action under something known as the active state doctrine or under something known as the foreign sovereign compulsion doctrine. Those are rules that provide a defense against antitrust liability in certain circumstances if someone was basically forced to do something by the foreign law. So what happened in this case is the Chinese government, by its Ministry of Commerce, it actually appeared as an amicus. That's just a non-party to a case who wants to express their opinion in the case. It appeared as an amicus in the district court below and said that, in fact, the price fixing was required under Chinese law. Now, the district court went ahead and decided disagreed with the official position, the position expressed by the Chinese Minister of Commerce, and said that based on other contemporaneous evidence, it didn't believe the Ministry of Commerce's representation. And this included a statement that the Chinese government had given before the World Trade Organization saying that China had given up export administration of vitamin C, among other things. So the district court basically didn't credit this representation by the Chinese government. Now, the circuit court, the Court of Appeals, overruled the district court, and it said basically, in this circumstance, when a foreign government appears in the litigation and says gives their interpretation of what their law means, that the court is required to defer to that if it's a reasonable interpretation of the law. So they basically said the district court was required to follow what the Chinese government said. The circuit court actually said the district court's careful balancing of the evidence would have been appropriate if China hadn't actually appeared in the litigation, but given that they had to defer to the Chinese government. So the big question here is, at the highest level, is how does a court determine the law of a foreign country? And this is governed by Federal Rule of Civil Procedure 44.1. Now, here's the language. It says, in determining foreign law, the court may consider any relevant material or source, including testimony, whether or not submitted by a party or admissible under the federal rules of evidence. So it basically says you can consider anything, but it doesn't specifically say how much weight to give it to any particular type of evidence. Now, the more specific question is, when you're determining the law of a foreign country, how much weight does a court give to assertions about the law that come from official agencies of that foreign government? And more specifically still, is the court required to defer to the foreign government's claimed interpretation of its own law? Now, Justice Ginsburg rejects the Second Circuit's rule. It says that courts do not have to defer to foreign governments. She looks at Rule 44.1 and notes that foreign law is considered a question of law. It's not a question of fact that needs to be pleaded and proved according to the laws of evidence. It's a question of law. And basically the idea of Rule 44.1 was to treat it similar to the way the courts treat American law, where the court has the ability to kind of weigh just different pieces of evidence on its own and determine what's the governing law. Now, she notes that the idea of comity, again, this is comity, the idea of respect given to the acts of other sovereigns. It requires very careful consideration of a foreign government's statements. But here's some quotes from the opinion. She says, quote, "But the appropriate weight in each case will depend upon the circumstances. A federal court is neither bound to adopt the foreign government's characterization nor required to ignore other relevant materials." And she goes on to say, "When a foreign government makes conflicting statements or, as here, offers an account in the context of litigation, there may be cause for caution in evaluating the foreign government's submission." And then finally, a final quote here. She says, "No single formula or rule will fit all cases in which foreign government described its own law. Relevant considerations include the statement's clarity, thoroughness, and support, its context and purpose, the transparency of the foreign legal system, the role and authority of the entity or official offering the statement, and the statement's consistency with the foreign government's past positions." So she basically gives courts broad leeway to consider a range of factors in determining whether or not to credit a representation by a foreign government. And so she says the Court of Appeals was wrong to consider the ministry's position binding on it. And this is also consistent with the way that federal courts treat state representations. So if a attorney general of a state makes representations to the federal government about what the state law means, the court will give some respect and deference to that representation, but is not consider itself bound by that. And the Justice Ginsburg criticizes the Court of Appeals for ignoring other relevant evidence, including past inconsistent statements by the Chinese government by binding itself by the ministry's position. She also looks at the reciprocity idea, the idea of what other countries do when considering United States law, and notes that the United States doesn't actually argue in foreign venues that its own filings in foreign courts are binding interpretations of U.S. law. So the United States doesn't ask for the kind of consideration that China is asking for here. And notice that this is consistent with two international treaties on how to determine foreign law. The U.S. isn't a signatory of those treaties, but she notes that this kind of represents international practice in this area. The result here basically is that the court doesn't address what actually is the correct interpretation of the Chinese law. It just sends it back to the Court of Appeals to consider it again in light of all the relevant evidence. And the court also doesn't touch the underlying legal issue of whether China's interpretation of the law would be a valid defense to antitrust liability. So that's still open in the lower courts. Now, I have another question from Sam A. also in the questions here. It says, "Is the Federal Rules of Civil Procedure an act enacted by Congress, or is it something the court formulates?" Now, that's interesting. It's kind of a hybrid situation. The Federal Rules of Civil Procedure, there's a body, a Judicial Conference. I'm sorry, the name was escaping me for a minute, but it's a body consisting of federal judges from various levels of the federal judiciary, and they're appointed by the Chief Justice of the Supreme Court. And that body is in charge of reviewing the federal rules. And in addition to the Federal Rules of Civil Procedure, there's Federal Rules of Appellate Procedure, and there's a couple other, the Federal Rules of Bankruptcy Procedure, other federal rules. This body is, they're responsible for reviewing that and then periodically updating it. And they do on a very regular basis. Many of the revisions or additions or changes to the rules are relatively minor, but occasionally there's more major changes to the rules. And so this Judicial Conference recommends changes to the rules. Those get sent to the Supreme Court, and the Supreme Court ultimately has the decision of whether to adopt those rule changes or not. But once the Supreme Court adopts certain rule changes, those are forwarded on to Congress, which then has the opportunity to overrule those changes. So Congress can step in and not allow those changes to take effect. So it's primarily the rules are put in place by the courts themselves, but through the Judicial Conference, this body. So that's where the rules of civil procedure come from. So moving on, this is to the final case. This is the second opinion from this morning, and the final case of the week is a case called Minnesota Voters Alliance v. Mansky. And this is a First Amendment case, and it was a 7-2 decision with the majority written by Chief Justice Roberts and a dissent by Justice Sotomayor joined by Justice Breyer. Now, this concerned a Minnesota statute, and this is dealing with election places, polling places, and it says, a political badge, political button, or political insignia may not be worn at or about the polling place on primary or election day. And then there are certain penalties associated with this, including potential misdemeanor criminal penalties. Now, the facts here is, let me move on. Well, okay, I'll give the basic facts in this case. So on election day, a man who was a representative of this organization called the Minnesota Voters Alliance, he was executive director of that organization. He showed up at the polling place wearing a T-shirt, a Tea Party T-shirt with the Gadsden flag, that's the "Don't Tread on Me" logo, and also a button which had the phrase "Please ID me." And it's kind of a reference to the political debates over voter ID laws for elections. And he was initially he was turned away and told he couldn't vote. Eventually, he was allowed to vote, but his name and information was recorded for potential criminal prosecution later. Now, this was specifically a test case. His organization had previously tried to challenge this law as unconstitutional under the First Amendment, and he had worn these things specifically to kind of provoke a test case in this in this case. So I'll just start with Chief Justice Roberts' majority opinion. Again, this is a 7-justice majority opinion. He begins by a historical account. He talks about early American elections and how they were really not private affairs. There was rampant electioneering, including the distribution of pre-printed ballots for partisan slates at the polling places. There was a lot of heckling and harassment of voters. And starting in the late 19th century, there were a number of reforms, which included the universal adoption of secret ballots, and restrictions on polling place electioneering. And notes that all 50 states plus the District of Columbia now have some sorts of restrictions on polling place electioneering. Now, the specific Minnesota scheme at issue in this case has 3 parts to it. The first is a prohibition of messages to vote for or refrain from voting a particular candidate or ballot question within 100 feet of the polling place. Now, that's not being challenged here, and that type of thing has been upheld in a previous Supreme Court case. There's also a prohibition on distributing political badges, political buttons, or other political insignia at or about the polling place. Now, that distribution provision is also not being challenged here. But the third part, the actual challenge here, is a provision that says political badge, political button, or other political insignia may not be worn at or about the polling place. And that's what's challenged here. Now, the policy in Minnesota is if someone is wearing one of those items, they're supposed to be requested to either cover or remove the insignia. And if they refuse, they're supposed to be allowed to vote, but their name is recorded to be referred to authorities for potential civil penalties or misdemeanor criminal prosecution. Now, all of these prohibitions, including this prohibition on wearing these political badges and such, date back more than a century. So these are not new laws. These have been on the books for a long time. So Chief Justice Roberts, what he does is this is a First Amendment challenge, and he does something. He starts with something that's known as forum analysis. This is when there's a location that's a public property, something controlled by the government. The courts they use something known as forum analysis, and where they have a different set of rules depending on the type of place that's involved. Now, one type of place is what's known as a traditional public forum, and this is the classic examples of this are public sidewalks or parks, which are considered to be classic places for First Amendment expression. And in those places, it's highly protected. And the states have a pretty high bar that they have to overcome if they want to restrict speech in those type of places. There's also things known as a designated public forum. That's some other place. It's not one of these traditional places like a park, but it's been intentionally opened up to the public for speech purposes, and that has basically the same standard as a traditional public forum. But the other type of location, and that's what's relevant here, is what's called a non-public forum. Now, this is when there's government property that is, here's a quote, not by tradition or designation a forum for public communication. The government can reserve this space for its own intended purposes and exclude speech as long as the restrictions are reasonable and not viewpoint based. So the government is not trying to discriminate based on the viewpoint being expressed. And the court basically says the interior of a polling place on election day is clearly a non-public forum. It's a space that's kind of being set aside for the purposes of voting, not for people to express themselves. And there's no claim here that the text of the ban itself, this is a challenge to the actual language of the statute, there's no claim that it's viewpoint discriminatory. So this basically rises or falls on whether this is reasonable, whether it meets the reasonableness test. So the court looks at one of its previous precedents, a case called Burson v. Freeman. That's the one that upheld a ban on specific electioneering communications within 100 feet of a polling place. And the court had in that case held that this was even under the traditional public forum framework, which is much more restrictive. Even under that, in that type of a forum, the court had said that this was okay. There were things like fraud, voter intimidation, confusion, and general disorder that were valid reasons that the state had for putting this in place. But the court notes that they didn't address this type of passive speech, these apparel and buttons, and didn't address the interior of the polling place, where the situation is a little different because it's accessible only to voters while they're voting. So it's not like someone can just set up camp and leaflet or have big posters all day long there. So it's a kind of a different context. And the court notes that other precedents have recognized that the non-disruptive nature of expressive apparel. It's different from, confronting and talking to someone face to face. It's just someone wearing something on their body. But the court says the polling place is a special place and there's special considerations. So these prior precedents about the non-disruptive nature of expressive apparel don't necessarily apply here. And the court notes that most states ban at least some apparel in polling place. Most states bar, at the very least, express statements of support for a particular candidate. So a T-shirt that said "Vote for Trump" or "Vote for Hillary," that would be banned in most states. Now there are a minority of states that do expressly allow any type of speech of this type of apparel worn by voters, but that's a minority position. So what the court does is Roberts looks at the specific line drawing being done here. And he looks at the language, political badge, political button, or other political insignia. The problem here is the word political is not defined in the statute, and it can have an extremely broad meaning. Now, Roberts suggests that just a button that just had the word vote on it could be deemed political under a very broad reading of it. And he criticizes the state of Minnesota for having given unclear or inconsistent definitions. The state had said that only words and symbols that an objectively reasonable observer would perceive as conveying a message about the electoral choices at issue in the polling place were covered by this provision. But the state has also specifically said that this is not limited to explicit campaign statements. The state has given official guidance to election workers, and the court looks at some of the things that this guidance says are prohibited. And so here are two of them the court specifically addresses in detail. It says, issue-oriented materials designed to influence or impact voting. So that's one category that the state regards as banned under this provision. But the state has taken the position that issue on this, an issue-oriented material, means any subject on which a candidate has taken a stance. So, for example, please ID me, the language on the button, voter ID is not something that's actually on the ballot in Minnesota, but candidates for election had taken positions on voter ID laws, so this was covered. Now, the court says, here's a quote, a rule whose fair enforcement requires an election judge to maintain a mental index of the platforms and positions of every candidate and party on the ballot is not reasonable. And the court moves on to a second banned category in the guidance, and it says apparel that's promoting a group with recognizable political views. Now, this is not limited to groups that are taking positions on candidates or ballot questions. Minnesota said that this applies to any group that has views on issues that are confronting voters in an election. And the court notes how broad this is. It notes that organizations such as the ACLU, the AARP, the World Wildlife Fund, and even Ben & Jerry's, they're all organizations that have taken public positions on political issues. So this could have a very broad reach. Now, Minnesota says this is limited to well-known positions, but the court is not pleased by this. It asks, well-known by whom? And this kind of determination would likely depend on the particular media consumption of election officials, which is not likely to lead to a fair application of this standard. The court, so for those reasons, the court basically says this is just not a reasonable way of trying to limit disruptive speech inside the polling place. The court also compares to the practice in other states and notes that a number of other states have prohibitions that are much more specific, limited, for example, to specifically things that mention certain candidates or ballot measures or political parties. And the court doesn't say that the states are required to be so limited, but just says that they must at least be much clearer than Minnesota's standard in order to be constitutional. So leaves open the question of how much speech state can restrict in the polling place and get away with under the standard. But Minnesota is just too fuzzy, too unclear, and potentially too broad to be reasonable. So there's this dissent by Justice Sotomayor, and this is joined by Justice Breyer. And it's an interesting dissent because it doesn't directly contest the court's First Amendment analysis, but instead argues for certification of the interpretation of this Minnesota law to the Minnesota Supreme Court. Now, let me explain what this means. Now, the laws of a particular state. Now, while the United States Supreme Court is considered the supreme arbiter of federal law and the U.S. Constitution, state Supreme Courts are generally considered the definitive authority on the meaning of state law. Now, some states, not all states, but some states have procedures that would allow a federal court to certify a question to the state Supreme Court on an issue of state law. So they can request a definitive resolution of state law for the federal court's purposes. For example, here, the federal court could ask the state Supreme Court, the Minnesota State Supreme Court, something like, what is the test for determining whether a badge, button, or insignia is political under the terms of this voting law? Now, a state Supreme Court doesn't have to accept a certified question. They can decline to answer that question. But if they choose to, the benefits of this kind of certification process is it gives kind of greater respect for the state courts and avoids unnecessary determinations by the federal court that are contrary to state law. And but there are some potential drawbacks too, because it causes some delays in litigation and can cause a waste of resources when you have more courts having to weigh in on a particular legal issue unnecessarily. Justice Sotomayor argues that there's a principle of avoidance, a constitutional avoidance, which says that before a court goes to declare a statute unconstitutional, it needs to assure itself that there isn't a different interpretation of the law that would be constitutional. And she says that federal courts should be very hesitant to adopt an unconstitutional interpretation of state law when the option is there to certify the question to the state court to get a definitive resolution of that. Now, Justice Roberts responded in the majority opinion in a footnote to Justice Sotomayor's positions here and says, first, Minnesota waited too long to try and seek this certification. He says they waited 7 years into this litigation to even suggest that certification was appropriate in this case. Justice Sotomayor responds to that, saying basically that's irrelevant. Certification's for the benefit of the federal courts in order to let it get the law right. It's not something the parties can just waive, and courts can even do that on their own initiative without any party requesting it. So she rejects that idea. And Justice Roberts also says this was unlikely to change anything. The Supreme Court decided this case based on Minnesota's own interpretation of its law. The state didn't offer any better alternative that it would recommend the Minnesota Supreme Court to adopt. Now, Justice Sotomayor disagrees with that, saying there's nothing that requires the Minnesota Supreme Court to adopt the position of the state, the organs of the state government. And she says they should give respect to the state Supreme Court by allowing it the opportunity to create its own more workable standard. And she argues further that she says that a constitutional interpretation of the Minnesota law is at least fairly possible. She thinks that the word political could be interpreted in a more manageable way, and points to other different contexts where the Supreme Court has upheld distinctions turning on whether something is political. And she also points to the history of the application of this law in Minnesota, noting that no one apparently in the long history of this law, no one has ever actually been denied the opportunity to vote or criminally prosecuted under this law, and says that given those facts, it's the concerns over the unequal application of this law, they just seem overblown. Now, Justice Sotomayor doesn't clearly address what she thinks of the First Amendment analysis under the majority's interpretation of the case. She, does promote this possibility of a narrower construction by the Minnesota Supreme Court, but she also does seem to cast some doubt on the majority's concerns about the unworkability of the state guidance. So it's not completely clear in the this is at this point impossible situation, but in the hypothetical situation where if this case were certified to the Minnesota Supreme Court, and the Minnesota Supreme Court came back with the exact same interpretation that the majority had worked with, it's not necessarily clear which way Justice Sotomayor would go in that particular circumstance based on her statements in her dissent. But that kind of brings me to the end of that opinion. Now, I want to note, I have one more comment in the live chat comments by Sam A. And it says, note, the opinion quotes Justice Alito's questioning during oral argument, which was novel. Now, this is very interesting. Justice Alito in oral argument had a series of questions for the counsel from Minnesota that were seemed pretty devastating and got a lot of attention after the oral argument was over. He gave a series of hypothetical questions about particular messages that might be on a t-shirt or button, and whether or not those would be political. And he asked about certain things, asked, would this be a political statement, would it not? And he eventually asked, what if someone had a t-shirt that had the language of the Second Amendment on the t-shirt? So just the language of the Second Amendment, saying the right of the people to keep and bear arms shall not be infringed, or whatever, on a t-shirt. Would that be a banned political insignia or political badge or whatever? And the attorney for Minnesota said, yes, it would. That's a controversial issue that politicians often take positions on. That could well be something prohibited. So Alito then turned to ask, what if the text on the t-shirt were the First Amendment? Saying that the Congress shall make no law abridging the freedom of speech, and that were on a t-shirt. Would that be something that could be banned? And the attorney was forced to kind of say no, backpedal, because he didn't want to be placed in the position of saying that the court could, or the state could pass a law that bans the printing of the language of the First Amendment, which protects the freedom of speech. So it was a very, you could just consider it a very clever set of hypotheticals that he posed to the attorney that kind of backed them into a corner and made the state's kind of determinations of what is or is not political seem very arbitrary and inconsistent. So it's just interesting because the court did bring that up in the opinion. So that brings me to the end of the 5 opinions for this week. So it's running a little long here, so I think I'll wrap it up with that. This kind of brings us to the end of the episode. Our next live stream will be a week from today, Thursday, June 21st at 9 p.m. Eastern Time. You can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Now, next week's live stream, the court had its private conference again earlier today. An orders list from that conference will be issued Monday morning at 9:30. So we can see if we get any new grants for next term in Monday's orders list. And opinions are also expected Monday morning at 10 a.m. Now, no additional opinion days have yet been announced, but it's a good bet that we'll get more opinions later in the week, probably on Thursday, like this week. Because, again, a reminder, there's only 2 weeks left before the court's self-imposed deadline, and there's still 19 cases outstanding. That's a lot. 9 to 10 cases a week is just a very high rate of opinion issuance by this court. And there's a number of major cases still pending, and these just include includes Carpenter v. United States. That's the big case about the government's access to cell site location data. There's the 2 partisan gerrymandering cases, Gill v. Whitford and Benesek v. Lamone, that are still outstanding. A case called Nifla v. Becerra, which is a challenge to California's FACT Act, which is a disclosure law for pregnancy centers relating to the availability of abortions. There's Janus v. Asks Me, which is a case about a union's ability to collect fees from non-members to cover collective bargaining costs. South Dakota Fair, which is about whether states can impose taxes on out-of-state internet sales. And last but not least, Trump v. Hawaii, the litigation over the legality of President Trump's travel ban, the ban on entry into the country by nationals of certain countries. So a lot to come, a lot of big cases that are expected to come down in the next 2 weeks. Now, whether you're watching on YouTube or listening to the audio podcast, I'd love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page, tweet at Counting to 5, or send an email to